Hello, everyone. I'm Vin Sylvia Jr., Director of Marketing and Communications at Sylvia Group, here to welcome you to today's webinar on how to mitigate the risk cyber exposures pose to your business. It looks like most of our attendees have logged in, but we'll allow late arrivals another minute or so before we begin the presentation. In the meantime, please notice the box that opens at the top of the presentation screen. That allows you to type in and submit a question. I'll keep an eye out for questions during the webinar, and I'll share any we receive with our presenters. Okay, it looks like we're all set to go now, so I'll start by introducing today's guests. Our first expert presenter is Privacy Breach Counsel John Mullen, a named partner and co-founder of the law firm Mullen Coughlin. John and his firm focus their practice on assisting insureds in preparing for and responding to data privacy and network security events. His emphasis today will be on the regulatory and litigatory aspects of cybersecurity and breaches. Practicing attorney for more than 25 years, John regularly presents on these subjects for businesses around the country, and he's been published and quoted as a national expert in multiple publications. Also joining us is someone with whom Sylvia Group has enjoyed a long and productive relationship in serving our clients, Chaz Bellingrath of ARC Excess and Surplus. Chaz, who also has previously worked with John on presentations similar to today's, will outline the evolving liabilities created by cyber, privacy, and security exposures, and he'll explain how to mitigate risks associated with those liabilities. With that, I'll turn the mic over to John and Chaz, with plans to jump in if we receive any questions. John?
Great, thanks. This is John, everybody, and Chaz and I chatted beforehand, and we are going to interrupt each other incessantly throughout the chat so that we keep you folks awake. It's also highly unlikely we're going to use 90 minutes, so you can probably gain back some time on the far end of this, because I think 90 is probably a little overkill for purposes of a webinar. So if you hear another voice coming in quickly, that'll be Chaz. He's going to be, like I said, interrupting and chatting with me on virtually every slide. Next slide, please. All right, well, while we're going to the next slide, I'll just sort of give you a little bit of background. I've been at this data privacy business since about 2002. My firm this year will handle 1,000 data privacy events. We work almost exclusively with the insurance industry, meaning the brokers of the world, like the folks on the phone, as well as all the big carriers, as well as London. I know that we mentioned a moment ago that Chaz and I have worked on presentations together, but I'll mention that Chaz and I have worked on dozens, if not scores, of actual data privacy / breach events over the last decade or so. So we've both been in the trenches together with clients of his, figuring out what to do, et cetera, and we're going to cover all that now. In terms of this first slide, this is sort of somewhat rudimentary, and the concept is this. When we all get out of school, I know my first insurance card, to prove that I had health insurance, my Social Security was the number. Now, when I sign my son up for hockey every year, the local Little League rink asks for his Social Security number. When I buy my daughter something at American Eagle for Christmas, they ask me for my email, my phone number, and every other thing that they can ask until I say no. So we all live in this culture where companies collect boatloads of data about individuals. They hold on to it because it's cheap, and it might or might not be helpful to them down the road for some reason. So, and that's the context in which we find ourselves. Through the 80s and 90s, no one on this call in those years got a letter from a company saying, hey, we lost your data. And the reason no one got it, and now you've all gotten one, is because now there are laws requiring it, and that's the real difference. Most companies cannot answer the questions that you're looking at. They seem pretty basic, don't they? Where is it? What is it? Who has it? Who has access to it? When do you get rid of it? Not so basic. I've had this conversation with hundreds of IT people, and they admit that as simple as these seem, they're on the edge of impossible to be able to know 100%. Next slide. I'll be curious to get Chaz's comments on this one. But I will tell you, I drop the threats into three big buckets, and these are those. The threats that we see, the malicious actor used to be sort of a third on this slide. And I used to say to people, look, no one has perfect IT, but even if you do you also have perfect employees? And even if you do, how about your vendors that you use? So that it's a cascading risk. It's either you have an attack on you, your employees make a mistake and fall for something, or somebody you do business with that has access to your data, they have a problem. So realistically, there are a lot of different places where this comes in. By way of background, the malicious attacker is more common than it used to be. And the reason is because compared to 7 or 8 years ago, now there is an actual black market. It's called the dark web, where you can go and sell stolen information or buy stolen information. I think the latest I heard was a social security number and a name might be worth $1. Healthcare information about a person, a full suite of healthcare information, might be worth $20. A credit card might be worth $0.25. So they're out there. Not only that, but on this dark web, which I wouldn't advise you go to. If you went there, you can also buy hacking kits. So it gets to the edge of ludicrous, by the way, because you can go on for maybe $2,500, buy a hacking kit and try to hack a company. And if it doesn't work, there's actual customer service available to help you hack that company free of charge, included in your purchase price. I mean, it's crazy. You can also buy 10,000 credit cards, and if only 9,000 allow you to work fraudulently, they'll reimburse you with another 1,000 credit cards until you get up to the 10,000 actually that you can use fraudulently. So it's a pretty crazy environment. Go ahead,
yeah, the dark web is really a unbelievable space. And the other thing that I think is really interesting that a lot of people don't realize is in respects to ransomware, which I'm sure you were going to touch on next, is ransomware is done by organized crime organizations. These are offices. These are not kids in someone's garage requesting ransomware and demanding ransomware from personal individuals as well as companies. These are companies. You have benefits. You work 9 to 5. There is a customer service department that will answer your call if you have any difficulty transferring Bitcoin. These are actual organizations that wake up every morning and say, who are we going to attack today? Hackers and ransomware organizations and other groups, this stuff is real. They are attacking individuals. They are attacking businesses on an hourly basis. And this is real threats. John and I have seen a lot of our companies experience ransomware this year, and there's really been a huge uptick in the last couple of years. We'll get into some things later in our discussion on how to prevent ransomware attacks from happening. It really starts with employee training, but that we will get to that later in the discussion. The other thing to talk about too is business partners. As organizations, just within my organization or John's organization, think about how many vendors we use. That little blue recycling bin that you have underneath your desk or, in the corner of the office somewhere, you're putting sensitive data in there. So that shredding company, that Iron Mountain or whoever you guys use is a vendor. Even the cleaning people that come in at night. We always tell our customers to, try to push a clean desk policy. Well, that's certainly difficult for some people. And think about just the information you leave on your desk that someone, a custodian or a cleaning organization might have access to. So when we're talking about vendors, we're not just talking about, cloud storage providers and things of that nature. We're actually talking about other vendors that we use just to operate our business, like a cleaning company, like a shredding company. So just something important to note. Next slide, please.
Yeah, and let me finish this thing for Chaz. Every one of those examples he just gave you, we've had a dozen data privacy / breaches over the years. Shredding companies, cleaning companies, people packaging up thousands of pages of paper thinking it was just going in the local dumpster. It gets spilled all over the streets a mile away and it's in the papers the next morning. So, or it's out there in the media. So it's a real thing. The other thing on ransomware, and I know we will circle back to this, ransomware has sensitized many businesses that frankly used to say to the market, We don't have a lot of PII, maybe about our own employees, but we don't have personally identifiable information. So why do we care? The manufacturers, I know there's some on the call, those folks are now worried, and appropriately so, that ransomware can come in and just stop their operations. And we've certainly had plenty of those. We have about 5 net new cases every single business day of the year. And I'd say 2 of the 5 per day are ransomware somewhere across the country. So this slide is really just to illustrate the basics of what it is that's, generally speaking, protected under the laws in the United States and other countries. And it's all about understanding what these definitions are. And they're relatively simple. Payment card, we know that's simple, right? That's debit cards, credit cards. So that's pretty clear. Contracts at the bottom, that's simple in the sense, not simple, but simple in concept, because that's whatever you agree to in a contract as defined by the contract. The point there being, 5 years ago, contracts didn't used to have any definitions of what is or isn't protected, or how you should or shouldn't notify a vendor, B2B client about an event that may have happened. Now those contracts are riddled with that kind of information, so you should be looking at your contracts. The 2 bigger ones going north on this slide, healthcare information, PHI, right? Everybody thinks they know what that is. Let me just give you an example why it's not always the case. Anthem, which is a massive insurer, had a big breach 2 years ago. I think it was 86 million records owned by 260,000 client B2B companies that Anthem provided to employee health care. So that's a pretty big number. What Anthem ultimately lost was a list of names and social security numbers. Does anybody on this phone think a list of names and social security numbers would generally be considered healthcare? Doesn't seem like it, right? But the reality was, because Anthem was subject to HIPAA as a covered entity, that definition included just those 2 items. So it's kind of weird. So just don't be so sure you know what healthcare information is under some statute until you look at the statute. And then the top one is where we get a lot of change, and that's PII. That's sort of the catch-all of everything else. I used to say PII was your name attached to some data element that doesn't change, like license plate number, like social security number, or those kind of numbers, some kind of state-provided thing, like a passport even. But that's all changed because now these states keep changing their laws, and now things like username and password, which you can change in 2 minutes, if that's lost, even if it's old, that's considered protected information in some jurisdictions. Next slide. So as we flip over to this next slide, it says state regulatory exposures. Here, this is just to illustrate the complexity. It is truly a quilt and a matrix of laws in the country. We're going to go through some of it without putting you to sleep, hopefully. I'm not going to read slides to you, but 48 states, they're all a little bit different. They all have different laws. The couple things that stand out in these are, generally speaking, they all have a couple elements that are similar. One is that when certain data is compromised in a certain way, that the company who has that data has to notify the consumers or the employees that that data is out the door in writing. And there's all kinds of different rules about how you have to write it, who has to see it, when it has to be done by, etc. The other thing is, about half the states in the 20s require that you tell some state entity about it. So not only do you have to tell, just making it up, all the people in New Jersey whose data you lost, that you lost it, but you also have to tell the state police in New Jersey and the Attorney General in New Jersey. So you're in effect having to tell on yourself to the teacher. The teacher, meaning the government in that state, can then decide, are they going to inquire into this event or not? And that is totally random. Sometimes they do, sometimes they don't. Some states enforce constantly, some don't at all. You just never know. But the point there is, when you're the entity that has that data that is then in some way compromised, and it's all very subtle how you determine that, because compromise can mean a lot of things, you then are on the hook for doing notice, oftentimes across all 48 states, and telling about half of those state attorney generals that you've had this problem. So there's all kinds of different time frames, et cetera, and different things that play out there, but that's the gist of it. Next slide. Now, this isn't for you to read in any real sense. It's just to point out this is a handful of states who have changed their laws just in the last 12 months. So, we have 2018 up here because one of these takes effect in 2018. I think I have another slide. Yeah, I do. The next slide where you're going to see. So here you've got, between these two slides, you can flip back and forth. You're looking at 20-some states that have changed their already new laws in the last 2.5 years. So think about this. The way you look at risk is you look at the statute and you figure out how it works and then you comply with it. Well, all the statutes are under 15 years old and they keep changing them on you. And on top of that, depending on who's in the AG's office in any given state, what party, et cetera, what philosophy, they either are or they're not going to care about enforcing them. So it's a pretty tricky patchwork of things that you have to worry about. And one of the
John,
things I'm sure. Go ahead, Chad.
Sorry to interrupt you, but can you just quickly highlight Massachusetts, because most of the attendees on the call are Massachusetts residents, and I think in Massachusetts companies. I think it'd be helpful just to quickly talk about Massachusetts because, unfortunately in the state we live in, data security issues are, regulations are very strict, but also we have an AG in our previous AG who's been very active in investigating those data breaches. You just give us a quick 1 minute on that, please?
Yeah, so the short version in Massachusetts is, first of all, it's not just Mass. It's also Vermont and Connecticut. You live in a hotbed of enforcement. I'd say those three states, if I had to give a list of a half a dozen, they're on it in terms of the willingness of the state government to enforce these laws. So yes, Mass, but also, neighboring states. One of the things that jumps out, Mass has its definitions and you have to know them. They now make it public, as you can see with the highlighted piece here. So not only do you get to tell the teacher on yourself, the teacher publishes it online. So that's not good. The other thing is, the one thing that makes Massachusetts very unique, it's one of the few states, if not the only, that requires you have a written information security plan specific under the Massachusetts statute. So even if you're not in Mass and you don't have that plan in place, you have a problem if they come investigate you. And that requirement isn't new. That's been out there for, Chaz, 5-7 years now? So
yep.
It applies across the country. Now, for the first 3 or 4 years, although Mass does do a lot of investigations, they didn't really enforce that piece, but now they're asking, show me your written information security plan. And if you don't have it, it's just another nail in the coffin when they come to enforce and decide what to do with you next. So hopefully that helps.
And just to be clear, too, for everyone on the phone that hasn't gotten this message across, when we're talking about breaches, we're not just talking about cyber attacks. We're talking about paper as well. One of the most famous legacy regulatory investigations was in Massachusetts against Mass General, at least over 5-6 years now, and it was actually an incident where an employee left personal health information on the T. So keep in mind that this isn't just, hackers getting into your network and vendors and things like that. We're also talking about paper information. That would mean a Post-it note, a file, even a voicemail recording that had sensitive information, even a discussion at a bar. We've had incidents where that has come up where two doctors were discussing a patient and someone right next to them overheard it. So it's not just electronic. I want to make that 100% clear. That's very important.
Yeah, and I believe I recall that Mass General, to illustrate how kind of quasi-ridiculous the enforcement can be, if I have my facts right, I'm thinking back, it was a red well on a subway that was lost. It had records for about 190 people on it, never
Yep.
seen again,
Yep.
never misused by any real allegation, only the threat of. So here a red well disappears with some pretty sensitive information, HIV, that kind of thing, granted, but it disappears, probably burned at the end of the night in the dumpster at the end of the where they burn everything else, and yet it turned into a big enforcement case, a class action case, and as I recall, dozens of individual cases, all of which had to be resolved and defended and gotten rid of. So that's just paper. I've actually had about 4 or 5 microfiche cases, if you can believe it. Like companies who had microfiche, which goes back a while, and they were going to either get rid of it or image it and then get rid of it, and it was somehow lost or compromised, and that turned into a case. So,
Yep.
the complexities out there.
We actually have a pending case going on right now. It was on the Channel 5 News last night here in Boston, where a state organization lost a camera that had dead. It was actually the chief medical examiner's office, and they lost just a camera. And they're thinking, that people's faces, and I think they notified 801 families of the deceased individuals. So even a camera. It's maybe not sensitive data, but it's a picture of someone that could trigger the
And
back on track.
As I recall, that's okay. 60 Minutes did a piece a couple of years back about the hard drives that are on copiers in everybody's office. And if you don't clean those off and cleanse them when you turn those things back in or sell them or trash them, those hard drives have data and pretty much all the stuff that's ever been copied on them. So it can be pretty scary if you don't really think it through. Next slide, please. This is here just to illustrate, even if you know all the rules and they keep changing them and they're interpreted different, there are a bunch of states, and this isn't the entire list, where the rules don't even apply. And Connecticut being near you guys, I'll give you that one as an example. Maybe 2 years ago, they passed a law. They were the second state formally requiring credit monitoring to be offered Connecticut residents whose data is compromised. Okay, I get it. And they required 1 year. Now, we deal with all the attorney generals literally every day in our office because we have hundreds of cases open. And we started complying. So for Connecticut breaches where people from Connecticut were involved, those people were given 1 year of credit monitoring. We got a call pretty quickly from Connecticut saying, hey, we want 2 years. And we know these guys, and our answer was, guys, you just passed the law 6 months ago requiring a year, and we're complying. Can't we just comply with the law? Oh, yeah, you can do that, John. That's fine. Pause. Of course, we'll investigate your client. Oh, maybe we'll do 2 years since you want that. And that's really the way that went down. So it's an unwritten rule, right? Indiana, it says, get your notices out to people without unreasonable delay. But if you go 31 days, they consider that unreasonable by definition. So, the point being, there's all kinds of rules. They keep changing. And there's rules that aren't even rules that get enforced. On top of all of that, and I'm not going to give a legal law lesson here, but there's almost no case law interpreting any of it. Because they are new laws, there haven't been, battle royales where you end up making, appellate level decisions that you can refer to say, well, what do they mean by compromise? And what is PII really? And does this fact scenario really count and make us do notice? We're not sure. And that's frankly what we do at my firm. Next slide. So this is just an example, again, not too far away. New York came out with what I'll call a proscriptive data privacy requirement. Anybody who has to report to the Department of Financial Services, that can be brokers, insurance brokers, insurance companies, financial services companies. So it's relatively narrow, but we put it on here just to illustrate that as is HIPAA, we haven't talked about it yet, but HIPAA is all about proscriptive rules. You must do this, 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 and this. And then if you have a privacy event, you must do this and this. So they want you to have all these things in place, all these boxes checked, not unlike the Written Information Security Plan required by Massachusetts. Here is another one. And it's in New York, and it's a little scary because you don't necessarily have to be in New York. You just have to be subject to regulation by the Department of Financial Services in New York. I also think that this is going to be picked up by other states, and I think you're going to see a bunch of states come up with proscriptive rules, not just reactive rules. Because right now, most of those state laws are, if this happens, you must do that. But this is, you must do this ahead of time, and then if it happens, you must do that. Chaz, did you have something? I thought I heard you.
No, I agree with you that we'll have some copycat states follow. Absolutely.
Which does seem to be the trend. I wouldn't be surprised to see New York followed by Mass or followed by California or Connecticut. Those are the three that seem to get ahead of things. Next slide. So we're not going to pound through this, guys. I will tell you this, and I'll have some examples coming up. I'm often asked, hey, is there going to be a national law that gets rid of all 48 of these state laws? It's such a pain in the butt, and it'll simplify it greatly. And the answer is, look at the first dot. The first dot is when there was only 47 states, not 48, with data privacy laws, they all got together and ask yourself, when's the last time 47 state attorney generals ever agreed on anything? I would suggest it's been maybe never, right? But in this case, they did, and they wrote to Congress, and they said, hey, if you guys pass a law that purports to regulate data privacy and notices and all that stuff, do not mess with our laws. The message being, look, we have power within our states, our congressmen, our senators, and we're not going to let you do this. If you pass it, it better be in addition to, not instead of, our laws. So if we ever do see a national law on data privacy, it will highly likely be in addition to, not instead of, meaning it's just another level of complexity, not going to simplify anything. And to make that point, when Anthem had its monster 86 million record breach that I was talking about before, they also had to comply, not just with HIPAA, but with all 48 state laws as well. So I don't see, and Chaz, you may have a thought here, I don't know, I don't see a national law A being passed or B being passed and simplifying anything.
Yeah, I agree. I mean, it's been in the news a little bit this week, but I agree with you.
The other laws on this are just to illustrate, there's a lot of different laws depending on the status of your company, what you do, who you're subject to in terms of regulation. Some good news, the FTC has dialed back some of its enforcement actions. We had a few that we thought were going to be really significant, and the new administration pulled them back. So, sometimes you actually see that happen. It doesn't happen a lot, but, in fairness, I want to make sure that people hear that it actually did happen. Next slide. So this is here because it's not a statute, but the payment card industry, PCI for short, that's credit cards and debit cards. And when your company has them, and if they're compromised, then you've got a whole regime to go through in terms of investigations, et cetera, that will likely at the other end come out in some kind of fines, et cetera. So you have to do notice, you still trigger all the state laws, but you also get investigated by an auditor from Visa or suggested by Visa or MasterCard or Amex or Discovery, and you go through this whole thing. The problem with the PCI process is there's no kind of, you have no rights under, no legal rights, no due process. And why is that? It's a contract. It's a contract. It's not statutory. So you'd think, oh, that's not fair. For instance, if you're told we're fining you $1 million for the fraud caused by those 12,000 credit cards, and you say, okay, well, give me the math and the vectors that show that my 12,000 card loss turned into that $1 million. Their answer is no. And you can't get them to give it to you. And people have gone to court over it, and they still can't get them to give it to you because the courts say, look, you signed on to this. This is your agreement. It says right there they're not going to give it to you. So it feels a heck of a lot like legislative enforcement and statutory enforcement, but it's not. It's contractual. So just be aware it's out there. Next slide. So I'm not going to kill you with these slides. We can make these slides available to you folks, but this page is, and the next, they're really just here to illustrate that these states are impacting and are enforcing, different data privacy laws. I will point out, I kind of roughed up the average per record here on this page and the next, and it's sort of between $5 and $9 per record. So if you lost 10,000 records in most of the states, you can assume you might get a fine of 50 grand to 100 grand, like sort of in that range. So far, that's been largely consistent. Why don't we pop the next page so folks can scan it while we're talking. No, so and mind you, there's a lot of, usually when there's a fine like this, there's also been a lawsuit. There may be individual lawsuits. There's probably been a class action. So when there are fines that you see like these, you can bank on the fact that it's also likely that there have been lawsuits and perhaps some kind of federal implications as well. Go to the next slide, please. So these next few slides are all HIPAA fine examples. And let me give you something here to think about. I know a fair amount of manufacturers whose lawyers and brokers have come up with the idea over the years, and it's a good one. Hey, if you self-insure and have an insurance company sort of come in on the backside, then you kind of play the float on the health of your employees. If you self-insure for healthcare, then you're going to save some money over the course of a decade. Maybe 2 years it's bad, but 8 years it's good. It's worth it. So companies do that all the time. If you self-insure for healthcare, you are a covered entity, even if you build widgets and don't really touch the healthcare industry otherwise. So just be aware of that. the big difference between the state fines and these fines, and you can rough up the numbers, guys. On this page, the three averages are $533 per record, $47 per record, $567. So let's call it $400 a record. That's a whole different number than $5 to $8 a record. So if you're in healthcare as a covered entity or a business associate to a covered entity, you're looking down the pipe of HIPAA and the Office for Civil Rights. The numbers are way out of whack comparatively to the numbers I showed you for the state laws.
And John, just one quick point. Vin, if you could go back one or two. It's important to note here, guys, that we're not talking about millions of people being affected either. You know, when we talk about big data breaches, or when people think about big data breaches, they think about Target and Home Depot and Anthem and those kind of things. Look at some of the record counts on here, okay? 836 impacted individuals. I can confidently say that most of our customers have at least 836 or more records, just based on employee data that we have and been holding on to for the last couple of years. So look at that, a $475,000 settlement with an incident only involving 836 people. So just keep in mind, it's not just the big box stores with the millions and millions of credit cards. We're even talking about smaller breaches resulting in pretty significant fines.
And let's talk about that employee data for a second. You know, I often will have cases that come in and, you know, there's only 500 employees, guys. It's not that big a deal. And it's true. It's not a big deal, relatively speaking. Okay. And then in the conversation, I say to them, what's your turnover in employees per year? I don't know, 10, 20%. Okay. And in the data that you have in your HR system, do you also provide benefits to their kids and their spouses? Well, yeah. Okay. So now 500 becomes 16 or 1,700 if you figure a couple kids and a spouse each on average, you know, call it close to 2,000. So 500 becomes 2,000 records pretty quickly. And then you say you have 20% turnover. When's the last time you purged your HR system? And the answer is silence. And then the next question is, how old is your HR system? 10 years. So 2,000 with turnover and storage of 10 years just became 3,000 or 4,000. So you went from 500 to 3,000 or 4,000 pretty darn quick. And I'm just using that as an example of how data has a way of proliferating and getting a lot bigger than you really think of it when you think it through. This one here, hold on this one at the very top. It's the only one I'll go into any detail on. I find this one to be interesting. For years, we heard, and it didn't really see, that, oh, bring your own device. It's a problem. It's a problem. People have data on their cell phones enough to launch the Apollo 11, mission. That's all true. Well, here's a good example of a HIPAA case, a $650,000 fine for 400 patients on a lost iPhone. That's what that was. The iPhone went missing, never seen again. As far as I know, no one ever accused of actual fraud or misuse of the data, and they got tuned up for over $500,000 for under 500 records. Now, interestingly, in the world of HIPAA, you don't even have to tell the federal government about that breach until the following February. It's below the 500 threshold. So I'm sure somebody on this case was probably thinking, how bad can it be? It's not even 500. We'll tell them in February. And then they got whacked for 650. And trust me, when you get whacked for 650, the investigation that probably went in behind that cost more between the lawyers and all the effort. Here, one of the problems with HIPAA is it's enforced by the Office for Civil Rights. It's a federal enforcement agency tied to HIPAA. And what they do is they come in and say, oh, you had a breach on that date? Okay, thank you. We'd like to see 3 years or 4 years of all of your risk management, risk assessments, planning, training, enforcement of training tied to data privacy. We'd like to see that in 6 weeks. So then you have to cobble together that, if you even have it, to go back those 4 years. And then they start picking on you and finding violations, not just for the breach. In fact, that's just the door that gets open. It's for all the other stuff that you don't do perfectly. And frankly, no one can withstand one of those audits and get a 100% grade. It just doesn't happen. So it is a pretty tricky space in terms of the HIPAA piece for this. Next slide. Again, these are just a few more quick examples, and again, you can have these, but the numbers are not low. You know, these my averages on this page were sort of a 400 and a $130. So again, even on a page with lower examples, you're still looking at, on a per record basis, something in the neighborhood of $280 per record. Now contrast that, what we said earlier, the states average $5 to $10. So, you know, it's a whole different level. And then you start to think, wait, if this is the way the feds enforce their laws, do I really want a federal statute, quote unquote, simplifying the 48 states? Because guaranteed, you get a federal statute doing that, you get a federal agency enforcing it in the same fashion. Next slide. Briefly, we'll pound through a little bit of the litigation history here, guys. Here's the short version, and you can read for yourself, so I'm not going to really get into it, is these circuits here. First of all, 5 years ago, if somebody sued in a class action saying, hey, you lost 5,000 or 10,000 or 1 million records, we all have future risk of identity theft. That case got thrown out all the time. The judges knee-jerked it right out, said, look, there's no damages. It's 1 million people who may, underline may have a problem down the road. That's not damages. That's speculative. You're gone. You're out. Well, here are 4 circuits that you're not out anymore, right? And what's happening is human nature comes into play. 5 years ago, judges didn't have a kid, a spouse themselves who had identity theft. Now they do, or a neighbor. They see what a pain in the tush it is, and because it is, they're like, well, let me think about this some more. Maybe it's not speculative. Maybe today's day and age, with all the technology, it's real. There's a real risk. I'm gonna let this continue. And as anybody knows who manages risk, once you get past the motion to dismiss piece and you get into discovery, it gets more expensive and more risky. So these are up here just to show you places you don't want to get sued. I will unfortunately tell you this list will grow over the next several years. Next slide. These are circuits where we still win that battle. So there are more of them. Of course, 3 years ago, this list was longer, and the list I just showed you was shorter. So it's starting to even out a little bit. And as I said, I do believe some of these will eventually flip. Next slide. And we deal with these cases across the country. So we've had cases in every one of these circuits, and you know we've seen this evolution where I used to call it defenses eroding. They're still winnable, they're still settlable. No one in the United States has ever gotten to a jury on a data privacy case, but that's in part because now people are settling them for millions of dollars, and then these 2 circuits just haven't weighed in. Next slide. As you're looking at this, you know this is the only one where a case was ever certified as a class, and I don't want to get too far into the weeds. But I said no one's ever reached a jury. That's true. You also have to have a class certification happen, which here only happened once. But we do have examples where people prior to the certification issue are paying millions of dollars. The short version is this. I get a breach in, which, you know, I can tell you usually call 1 if you're getting sued or not. I'll tell you, if you lost over 1 million records, by definition, you're going to be sued by multiple law firms. If you lost over 50,000, maybe even 10,000 healthcare records, you're going to be sued. So that threshold is way lower for the plaintiffs to be interested. If you lose credit cards, you've probably got to lose six figures or maybe 7 figures to get sued. So you can lose a lot more credit cards and probably not be sued. Employees, I've seen W-2 scams where companies are tricked into sending out W-2s to a malicious actor. I've seen unions sue employers with only 1,000 records lost. So it really depends on the context, but generally speaking, you have to lose a fair amount of records unless it's employees or unless it's healthcare. Next slide. So these are just some examples. I'm not going to kill you with all the detail, but these are just some examples. I told you before, people settle out beforehand, right? Well, there's a big one, 115 million. That's a big number. Now, granted, they lost 86 million records, so you could do you could say, oh, John, it wasn't even two bucks a record. Okay, but it was still 115 million bucks. And trust me, the legal fees, the forensic fees, and everything else that went behind that, those numbers go up by probably tens of millions of dollars in terms of what was really spent. So let's go to the next slide. This is sort of a different sort of concept for you folks, and Chaz, I do want you to weigh in on this one.
Sure.
But this slide exemplifies one of the big reasons the insurance piece really comes into play. And I'll give you an example. Chaz has a case, which could happen, it happens all the time, where one of his clients has a ransomware event. It's a manufacturer. I'm going to get that call in about 3 hours from Chaz. No, make it 7 hours. It'll be this evening. I'll get a call from Chaz saying, John, one of my clients, they're in Connecticut. They're frozen. They don't know what to do. And by the way, we got this call not from Chaz 10 minutes before I started this call with you folks. What do? Well, have them call the 800 number. Who's their insurer? Pick an insurer. Doesn't matter. Most of them have 800 numbers. Most of them come right to us. So we get that call, and it's a panicked CEO or general counsel or COO or IT manager saying, all of our computers are frozen. We got hit with ransomware. It happened 3 hours ago. We don't know what to do. Can somebody help? Click. We call them back. We run through conflicts in about a minute. Call them back. Get them on the horn this evening because they call in at 5, let's say. We call them on we get them on the horn and we say, okay, let's establish a couple things. Your insurance company is X. We are approved panel counsel for them. As of this second, we are your lawyers. We have attorney-client privilege with you. We are not coverage counsel. We do not work for the insurance carrier. They are simply providing us as your lawyers because they know we do this for a living. We're either good at this or we're out of business because it's all we do. And we handled 1,000 of them this year and probably over 5,000 in the last decade. So we kind of establish who we are. And then we tell them, hey, guys, we've already Googled you. Tell us what's going on. We're going to interrupt you, not to be rude, but we're just going to interrupt you because we want to probe into the most important aspects of what's going on. We will come out of this call tonight at 7 p.m. with a plan that starts tonight. And then they walk us through the process. At the end of the process, it's ransomware. We say, among other things, we're going to flip you our retention, which is oftentimes free because a lot of the carriers will make it free or a low self-insured retention. And we'll give you our cell phones because I know your systems are frozen. And we're also going to get you on the phone with forensics. Now, that call was placed at, let's say, 5. We were on the phone with them by 5:15, setting up a formal call that started at 5:30. By 7, we were off that call, and we're telling them, and they're agreeing, you need forensics, and here's why. And they're like, yeah, we need them. Can we do it tomorrow? And we're able to say, well, while we were talking with you, we set up the call. It's set for 7:15 tonight. So everybody hit the bathroom, get a bottle of water. 15 minutes, we'll be back on a call with forensics. Forensics then jump on, approved forensics by the insurance carrier, so there's no fight there. And they're already helping them on that scoping call and going into the night, trying to figure out, among other things, do we have to pay ransom? What does the backup look like? Is this ransomware very, very virulent where it's going across all your different computers, or is it simpler and sort of deaf, dumb, and blind, et cetera? So that's an example of what this page really illustrates. We roll those people in. And another thing to think about before I kick it to Chaz for comments is, as they're having that event and they're telling me that they got hit with ransomware at 4:45 and everybody went home at 5:30 and all their computers were frozen, and let's make it a Friday, not a Tuesday. And I say to them, well, okay, we're on the road with forensics. We know we're good there, but you just sent, pick a number, 250 people home with frozen computers. Yep, we did. And I'm guessing you didn't have time to tell them what to say to their spouses or neighbors or what not to say. No, we didn't have a chance. Right. So now they're home over dinner, over the weekend, having a beer with a buddy locally. And the word gets out that company X has a ransomware event. And you can bank on it that you might have the local channel 6 at your door on, the next morning saying, is it true you're having a ransomware event? Is it involved with international, relations? Is it China? Is it Russia? All those kind of silly questions. But cyber is now cool with the media. It wasn't cool. It wasn't understood 5 years ago. Every little local media wants to do a cyber story. So on top of figuring out the forensics, we're also going to work with you immediately to come up with some messaging for your clients if they ask, for your employees, for the media. And frankly, we're hoping we don't have to use that prep, but a lot of times you do. And it just illustrates the fact that you're dealing with multiple work streams all at the same time, not to mention law enforcement. Not to mention the fact that you might actually have to pay and deal with Bitcoin and getting the wallet and all that if your backups are also polluted. So that's all sort of a blast at you guys, how this goes down immediately. But Chaz, if you want to jump in with some thoughts, that'd be great.
Yeah, thanks, John. And I think the best part about the coverage, and we'll get into it a little bit later, is you haven't even been sued yet. You've simply just had an event. In this case, you've had a ransomware attack on a Friday afternoon, and the clock is ticking, and you've already incurred a lot of expenses. And if you look at the rest of your insurance portfolio, you're going to find out, unless you have cyber and privacy coverage, you're on your own. Your D&O is not going to provide any coverage. Your property, your GL, your crime, your professional liability in many cases, you're not going to have coverage. And that's the real big part about this is most of the people we work with are first-time buyers, and making sure that they understand the ins and outs of this policy and what the policy can do for them and benefit them and be their really financial backbone in the case this type of thing happens. We actually just had a very similar case. Actually, John's firm was handling it, but that the employees that they sent home, they actually put a notification on Facebook, and that's how the news got alerted about the incident. So, the interesting part is that, we're not talking about any sensitive data released. We're not talking about PII. We're not talking about PHI. We're simply just talking about a little ransomware attack that can cause a lot of damage. And it was probably caused because someone clicked on a link, or, there was some type of social engineering or phishing event. So even these little incidents can really rack up some serious expenses. And the good news is the carriers have people like John in the back room to really help and hold your hand during this type of incident. But we'll get more into the insurance in a couple slides, but that is, a very crucial part of the cover.
It is almost amusing because I kid people and I'll say, look, if I had to call an 800 number that an insurance carrier gave me, what is my expectation I'm going to get help ever? Pretty low. I figure I'm just leaving it. It's pro forma. I'm not getting any real help. The reality here is you call that 800 number, it's in your policy, or Chaz will get it to you, or somebody on the broking team. You're getting a call back in 15, 20 minutes. You're going to have real substantive help with lawyers within the hour, and you're going to have forensics rolling in that night, even on a weekend, even on a holiday. All of which happens, as Chaz points out, months, years, or ever before anybody gets sued. So there is no quote unquote action. It's all first party. It's all immediate crisis management. Most policies don't give you that unless it's a cyber policy. And my quick way of saying it is this: look, we'll take 1,000 calls this year. Maybe 25 of them will be guys like Chaz calling me saying, "Hey, I was talking to this company for the last 2 years. They haven't placed cyber yet. They just got hit with ransomware. They need help." Now, think of the stress involved when I'm taking that call that I went through a minute or two ago. Think of the CEO, the general counsel, the IT director. They're all on this call, and somebody thinks they're getting fired, right? And they have insurance in place, and they're getting our help. So it's a highly stressful call. And our job is to make sure everybody knows, guys, there's a plan. We've gone through it a million times. We'll take care of you. We'll get this resolved. We'll figure it out. But that's the message we're trying to deliver as we get through that process. With all that stress, now think about all that stress and think about no insurance behind it, right? So in my example, 975 companies have that stressful call with us. 25 have it with no insurance. That's a whole different level of stress. I'll tell you that. So anyway, playing out this slide, after that initial blast of lawyers and forensics and everybody helping, what happens next is we get the forensics to tell us, was this the kind of data that was frozen, that was actually accessed or taken by anybody? And play it out on the negative just to illustrate the point. Let's say, yeah, well, you know what? They had 10,000 records, but 500 of them were taken. And the rest of them were just frozen and unfrozen because we freed them up. Okay, good. So now we have to do notice to 500 people. It's not that bad. But even if it's 5,000, it's not that bad. And that's when we go out and get, again, vendors approved by the carriers who will do the call center, who will make sure the letters are sent to the right, most current addresses, who will do the return mail and manage that. They will sign people up for credit monitoring. They'll make sure it all happens within 30 seconds of someone placing a phone call. They'll give you reports on, these are the people we mailed it to, these are the people who called, these are the people who signed up. All of that sort of data dump is needed because the regulators come in later and saying, show us the proof that you did it. Show us the proof that you tracked the return mail. Show us the proof of who called and who's signing up and who isn't, by the numbers, if not by the individuals. So all of that stuff happens. And then once you crank out those letters, you sort of cross your fingers. We've now mailed out 500 letters, but we've also told 17 state attorney generals, we have this breach. It's not just the 500, it's the state governments that they live in. And now you cross your fingers and you wonder, am I getting sued? Probably not with that number. And am I getting investigated by a regulator? Probably. I'd say 80% of the cases have a regulator investigation. I'd say 1% of the cases turn into cases, meaning class action cases. So the class action risk is not high, but it's real. The regulatory investigation is significant and highly likely. And we take you through that whole process, and it's all covered under the insurance, which is sort of the beauty of it.
Can I interrupt with a question here?
Sure, of course.
We have from one of our participants this question. Do we need to notify a government agency if we are holding social security numbers and driver's license information?
So the answer is, for holding them, no. But if you lose them, however lose or compromise is defined under the statutes that apply, then assuming there are names attached to those data elements, and the answer is yes. So if you're holding names and driver's license or names and socials and you get hacked or someone loses your data or a vendor loses it or a ransomware event occurs where you can't show that it didn't go out the system, the answer is yes. But how one defines access is also tricky. Not to get too technical, some states say you have to do notice if data is taken and misused. Other states say if unauthorized access occurs, some states allow you to do a risk assessment. So there's a lot of variables, and that's where some of the lawyering comes in. Philosophically, if we think that you're going to get hammered if you play it too close with the rules, we're going to do notice. But in that instance, those are two prime examples of data that are protected in almost every state. Hopefully that helps. So why don't we go to the next slide? So these are just some things to think about, post-incident or even prior to the incident. The idea here is you should have some kind of plan in place, an incident response team, an incident response plan. When and if you have that day where you need the help because you're having that event, whatever it is, a rogue employee who took data, the vendor who screwed up. I'll tell you this, my own firm, we're about as sensitive to data management as anybody, right? You can imagine. We don't even take in from our clients protected data. We won't take it. We don't want it. It's not needed for part of what we do entirely. We ourselves had a vendor who did our benefits who got hacked. So guess what? We had to do notice to our own people and give them credit monitoring, and we didn't do anything wrong. So just to illustrate the point, we're about as teed up on these issues as anybody in the world, and we still had to do notice to our own people because our vendor screwed up. So just to make the example, in terms of having a plan, be careful, and you'll notice I keep calling it data privacy events. I used to say breach events. Oh, somebody's calling me with a breach. Technically, I like to say this. It's not a breach until your lawyer tells you it's a breach, because when you say breach, you're implying you've triggered a bunch of legal duties to do notice. So I know it's a little picayune, but just be careful with some of your terminology. Next slide. We've had cases, on this top one is a great example. The CEO is highly sensitive that data privacy is a real thing and they want to be compliant. And we had one company call us. It was a manufacturing company. They had 130,000 letters ready to go. They were prepared to sign the contract, to get the letters cranked out, and they were going to do notice to all 50 states across Germany, overseas, etc. They had not done forensics. They had done internal forensic review. They hired us at the last minute. We got in there, brought in forensics. Forensics probably cost them 75, 80 grand. They did do notice after that. They did notice to 11 people. So they went from 130,000 people to 11. I think that was money well spent, because trust me, they would have spent $250,000 just doing notice instead of doing notice to 11 people. So it just points out you do not rush to go public. That said, you can't play fast and loose with the rules either. You can't quote unquote investigate for 6 months and then finally get around to doing notice. Not unlike a certain company out there that provides taxi cab replacements, right? I mean, why don't you wait a couple of years? Prepare for litigation. Just assume you're getting sued, even if you don't, because then you're going to do a document hold. Be ready, because if a regulator comes knocking, even if you don't get sued, having gone through that precaution, you're going to be in a better place to respond to a regulator. Conduct a risk assessment is pretty obvious. If you haven't done an outside risk assessment by now, you're behind the 8 ball. There are millions of companies that do it, some for a fortune, some at a reasonable price. We can tell you both. We don't do it. But an objective viewpoint, looking at your systems and policies and procedures and giving you grades is a great starting point. And frankly, it's an expected starting point by any regulator in the country. So you ought to do that. Next slide. Just about coming to the end of my slides here. I'll say this. If I ask you, if you have a breach in 2 hours, who's in charge of making all the decisions on hiring vendors, on moving forward with median, responses, on telling employees what? If more than one person raises their hand in your office, then you're not ready. You have to have somebody who's actually in charge on that first phone call with the authority. Because think about it. What if the call is Friday night at 7 o'clock, and I tell you you need to hire XYZ forensics in addition to us, and you need to do it now. And by the way, they require a retainer of 50 grand. If you're not able to do that on that call, you're frozen. So empower an executive to actually be able to act on behalf of the company. And the other thing I would say is, and I already made this point, and I'm not saying it just because we're in the insurance context on this call. If you don't have insurance for this, then you have a much bigger problem. So I always tell people, get assessed by an outside company, put somebody in charge, get insurance in place, and you've taken 3 big steps towards being a lot safer risk. Chad, I don't know if you have any thoughts. I think it's all yours after this.
No, thank you, John. That was excellent. Then if you could skip toward my piece, that would be great. Thank you. Go ahead. Go one more. So we'll lighten the mood a little bit with a quick comic. And I found this one just on the internet, and I think it's a great kind of overview of what we've been talking about. John hit on the laws and regulations, and in addition to some of the statutory requirements and federal requirements, obviously there is risk management that all of our companies are striving toward. With firewalls and encryption and antivirus and, so your whole IT team and whole enterprise of your company is in the left-hand corner of the screen, and in the right-hand corner you have Dave. And Dave is the guy who, maybe he's been with the company a long time, maybe he just started, and he accidentally clicks on that link that engages the ransomware. And everything that you've been working so hard toward, everything that the IT department has invested in and worked hard toward is really ruined with a click of a button. So, although we always talk about hackers, even the employee error, the negligence, the leaving the laptop at a coffee store or at the airport, we still see that those type of incidents really on a daily basis. Next slide, please. So the good news is that there is coverage for this. We've been talking about the insurance coverage, and this is really my section of the presentation. So we're going to go over, what is security and privacy liability. Security and privacy liability has actually been around for a long time. It's been around since the late 1990s. At that time, it was really just a third-party liability policy for network security and internet media concerns. Now, the policies have really evolved. If you look at the top of the screen, the title of my presentation is The Evolving Liabilities of Cyber Privacy and Security Exposures. And not only have the exposures evolved over time, but the policies have as well. Next slide, please. So in these policies, you really essentially have 3 buckets of coverage. Your first 2 buckets are in the first party coverages. So really, if you focus on the top half of this first screen with first-party breach response expenses, that's your first bucket of coverage. And that's what John and I were talking about earlier with the example of the ransomware attack on a Friday afternoon. So when that type of attack occurs, let's just use that as an example, the cost to hire a breach coach, which is John's firm, to help you with those legal services and guidance is an expense you're going to incur. The cost to hire a computer security or forensic expert, like we talked about, is a cost you're going to incur. If individual, personal identifiable, personal health, or any sensitive data is compromised during that attack, you will need to notify the affected individuals pursuant to the either state or federal law requirements. In some cases, you may need to provide credit or identity monitoring to those individuals. So for example, going back to John's slide with Connecticut and offering the 2 years of credit monitoring, if we do have a resident of the state of Connecticut that is impacted by our incident, we will need to notify them based on those Connecticut data breach laws. So that's important to to recognize. Even if we are a Massachusetts company, but we have customers that reside in Connecticut, we have to notify them based on where they reside. Okay, so another expense. Of course, when these notification letters come out, a bunch of people are going to have questions. Setting up a call center is going to be crucial. All right, going back to that ransomware example, if one of the employees who's sent home posts something on Facebook that the company was affected by ransomware, okay, we may need to hire a public relations or crisis management firm to help remediate some of the reputational harm or potential harm that ransomware may cause. So if you're looking at the first bucket of your coverage, it is really breach response expenses. You have not been sued, you've simply just had an incident, and you are responding to that incident. Your second bucket of coverage, again, is a first-party coverage and comes on the cyber business interruption, cyber extortion, and data restoration side. So again, using John's example with the ransomware demand comes in at 5 o'clock on the Friday, and we determine that we need to pay the ransom. That is cyber extortion coverage afforded under a cyber policy. So the cyber extortion coverage will pay the demand. Okay? Now, the interesting thing that we are seeing in the market is, let's say you pay the demand, but the key, the encryption key that the bad guys give you to unlock your computers has malware on it. And all of a sudden, our network shuts down. Our data is deleted, destroyed, altered. We have a business interruption loss. Now, most of you probably buy business interruption in conjunction with your property insurance. That generally covers fires and other covered perils. In this case, your building is still standing. Your servers are still in the room. The computers are all on the desk, but nothing works. Your networks are down. You incur a loss of income or extra expenses. Those cyber business interruption costs will be covered in that second bucket, as well as any cost to recreate any damaged information. So again, going back to the second bucket of first-party coverage, that's the business interruption, the data restoration, and cyber extortion. Again, you have not been sued yet. You simply are just responding to an incident. Okay? So in review of our first-party coverages, this is really some of the core coverages and really probably what our insureds use the most today when it comes to the insurance on a cyber privacy and security policy. This is some of the most valuable coverage within that policy form. Next slide, please. Your final bucket is your third-party bucket. Okay, so the breach occurred, the incident occurred, again going back to that ransomware attack, but now people were affected, and we did have to notify an attorney general. We had to notify the Massachusetts Attorney General, let's use that. And you know what, they're going to investigate. So there's regulatory action, there's a regulatory investigation. They determined that you failed to prevent unauthorized access to sensitive data, you failed to maintain reasonable security measures, and we're bringing action. So all of a sudden, this little incident has turned into a third-party liability incident. And again, we're going to see defense costs, we're going to see damages potentially fines, penalties, or assessments. I don't want to leave out the PCI fines and penalties because I think that's important. So, separate from our ransomware incident, let's say you were a retailer, or let's say you're even a healthcare entity that had a incident that involved payment card information. If any fines, penalties, or assessments came from the brands, going back to John's slide about Visa, MasterCard, American Express, addressing fines, penalties, or assessments against your company for that fraud that occurred. That would include card reissuance costs, and all of our new cards with the chip in it. Those cards, the cost to reissue those cards is about $3 more than the old cards with the magnetic stripe. So these fines and penalties and assessments are getting very large very quickly, and each brand will bring action individually.
Hey, Chaz, one thing to think about there that makes it even more difficult to deal with it is they already have your money. It's not like you get a bill and then you have to figure out how to pay it. Because of the way the processing process works, they have your money. So when they decide they're keeping your money, they just don't give it to you. So it's not like you have much control over it.
Exactly. Great point, John. Next slide, please. So first of all, we really appreciate all the attendees and, of course, Sylvia Group for allowing us to speak to you today. John and I just want to touch on some of the conclusion. Hopefully we haven't scared too many of you. Hopefully some of you guys have the coverage. Obviously, if you need any help with it, we would be more than willing to meet with you or have a conversation with you. This stuff is real. It's not if but when. Of course, every organization in America and really across the globe today has these cyber privacy and security exposures, whether it's on the risk management side, on the statutory and federal side, certainly the financial side of things, and that's where the insurance comes in. This stuff is happening. It's happening on a daily basis. The cost can be significant. Chances are, if you do not have a dedicated policy, none of your other traditional insurance like GL or professional D&O or property is going to have any coverage extensions. So look and talk to your Sylvia representative about cyber insurance. It's certainly a very important need, and chances are you could be bare in this area right now. John, I don't know if you have any things that you would like to discuss in closing, but that's it from my end.
Yeah, I think I'm good. I think I made my point on the insurance piece. It's a very complicated area. It's new. And I guess the one other thing I would tell you is just make sure you use experts. There's not a lot of forensic companies, not a lot of lawyers, not a lot of PR people who actually understand it, not to mention brokers. So a lot of people say they know it, but ask them how many they've handled, meaning all of the above. So just something to think about.
Yeah. Well, Vin, I think we're all set on our end. Again, thank you for giving us the opportunity to speak to your clients this morning. If anyone has any questions, John and I would certainly be available, throughout the remaining part of the year.
Great. Thanks, everybody.
Thank you, John. Thank you, Chaz. That was a great presentation. I'd like to point out as well that John Beauregard, our Executive Vice President, was going to host us, but he had an emergency to attend this morning. John is terrific at what he does. If you have any questions, if you'd like to contact John, I'm sure he'll get back to you in timely fashion, and he would be a great assistance to you. So thank you again for joining us, and have a great day.